Morning.
Morning.
First case this morning is North Carolina Department of Revenue versus FSC 2 LLC. We will hear from the appellant.
Good morning. May it please the court. My name is Jonathan White. I'm with the Department of Justice. I represent the Department of Revenue. I'd like to reserve 8 minutes. Your Honors, I want to talk about why this case is important and the problems created and left hanging by the decision below. The decision below would potentially gut the sales tax, and it would thwart the legislative purpose behind this exemption. First of all, it would make for a huge hole in the sales tax. Anyone who purchases an item that can be used to make something new could then turn around and claim a lower rate simply because they use it to make something new, according to FSC's reasoning, or because they use it to make new things as a hobby and sell one or two to their neighbors per the business court's reasoning. That won't work. It's inconsistent with the notion of a manufacturing industry or plant, a manufacturer, the process of manufacturing, or whatever term is used. Consumer purchases are supposed to add to sales tax revenues, not reduce them. Consumer purchases are supposed to recoup the sales tax that is sacrificed when real mill machinery is exempted. This decision would allow anyone to claim to be a manufacturer and buy all sorts of consumer goods at a reduced sales tax rate.
But isn't that really an argument that the General Assembly needs to just define the term manufacturer? Because I think what your friend is going to argue is, we're just looking at the meaning of that term, and this may feel a little bit like a loophole that, in a case like this where you're only a small amount of what you're manufacturing you're actually selling to others, but you're still a manufacturer, and if the General Assembly doesn't want that, let them define the term.
Your Honor, General Assembly could define the term, but the General Assembly has not refined the term in light of this court's several decisions going back many decades that do put a gloss on the term manufacturer. FSC is likely to argue again that the plain meaning of the language manufacturing industry or plant means that that's where we stop. But that's kind of old think. It disregards this court's reasoning in the case of Clayton Marcus, which takes a little bit of analysis, but it's very clear what the court is saying. As to, if the court remembers the swatch books, that the company that was clearly a manufacturer made for its own purposes for promoting the furniture. The court said, as to the swatch books, this is not a manufacturer. So on that day when it made the swatch books, it took fabric samples out of inventory, combined them together into a model. It was not a manufacturer as to those swatch books. Under that reasoning, which is old, which the department has relied on, and which the General Assembly has not disturbed, what may ordinarily look like a manufacturer simply because it makes something new is not one.
Your friend could argue the difference is that FSC is not saying, hey, look at this asphalt, which is a great indication of the kind of asphalt that when we provide our contracting services we use in our product. They're just saying, buy this asphalt. And that's different than the swatch books, which are not intended to be a kind of standalone product that you would purchase and use for something.
Your Honor, the principle is the same, that as to and it also has to do with the concept of a contractor, which is what the department thinks that FSC is, what FSC most days of the week thinks that it is. A contractor, if I refer to the court to the cases from other jurisdictions cited in Clayton Marcus. The first one is called Eden. It has the various ones that have to do with a company that would sell logs, but it used some logs for itself. There was a company that made storage bags. It used some for itself. As to things like that, that company is not a manufacturer. The difference in this case is only the proportion. It's as if the bag company mostly used its own bags and sold a few sort of extra. I'd like to continue with sort of what problems this poses for the sales tax. And go back to the purpose of the exemption to begin with. When it forgoes, ordinarily, equipment used to make products by a factory, for example, would be taxed, and they would usually be pretty expensive, and that would, of course, thwart development and investment and job creation. But the General Assembly has to make a choice when it exempts those are consumer goods at that point, but it has to make a decision. Will we get something in return when we exempt those or tax them at a lower rate? And it figures that it will, because those will be used to make thousands or millions of widgets that will then return the sales tax to the state. The state will sort of cast its bread upon the waters, and it will be returned. This case gives us the situation where the bread, it's a terrible pun, but the bread will be cast upon the waters, and it will not be returned. Why? Because this is mostly a contractor, and we feel that if we have to decide which is it between a manufacturer and a contractor, it's a contractor. It's a contractor that happens to sell some of what it produces for itself. That being the case, as a contractor, FSC will not be recouping for the state or any subsequent wholesaler or retailer, recouping for the state the sales tax revenue that is foregone when the exemption is made. A contractor is the consumer of the goods that it uses. That's its ordinary role as a contractor. That being the case, I mean, this all sort of fits into a single scheme of sales and use taxation. That being the case, it will not be later, selling products that the sales tax will be made back on. The court below disagreed with the department's reasoning that there needed to be that there needed to be two requirements. An additional requirement that FSC sell most of what it produces. And that is a reasonable requirement that relies on several cases from this court. But I'd like to ask the court, just pose a question and say, what if the roles were reversed here? What if there were a higher tax rate based on being a manufacturer? And the Department of Revenue said to FSC, you do a little bit of sales. We think that to a certain extent you are a manufacturer. That means that you are completely a manufacturer. In other words, minority rules, okay? What you do to a relatively small degree determines what you do overall. That's the wrong result. That would be the wrong result. If FSC used only a little, say 20%, which is the proportion here, but flipped, if FSC used only a little of what it, yes, okay. If that made it a manufacturer to sell only a little, and that made a higher tax rate, then if the department said, okay, we saw you manufacturing because you are selling a small amount of what you do, then you have to, then you are a manufacturer and you have to pay at a higher rate.
Don't you have a textual problem, though? I mean, what you want us to do is to read into the statute the word primarily, right, when it comes to what qualifies as a manufacturer. But in the statute itself, in the delicatessen restaurant exception to the manufacturer category, we see the words principally engaged. So a delicatessen, a cafe, etc., doesn't qualify as a manufacturer for purposes of the privilege tax if it's principally engaged in retail sales. So when we have a statute in which the General Assembly has used that kind of language, it's clear that if the General Assembly had intended for manufacturer to mean only a company that's primarily engaged in manufacturing, it could have used similar language, couldn't it? And we wouldn't be here.
We might not be here, Your Honor. However, I'd point the court to both the outcome and the reasoning of the Midrex case, and it's a similar situation where the Department of Revenue and the taxpayer have to make a single conclusion. What is this thing? Not some sort of hybrid, but what is it? Because that's going to determine how it is taxed. And in this case, the court noted that the word primarily could be there, but was not, and did not read it in, but said, you know, this has got to be part of the reasoning. This court has, in essence, and I want to find the cases. This court has, in essence, seen a primary requirement in the admittedly kind of small body of case law that we're dealing with, beginning with Henderson v. Gill. And let me see if I can have the, okay.
But in Midrex, did that involve a statute in which the term principally engaged appeared?
It was not.
Right, and so that's my point, is that it seems like something of a stretch to say, well, we've got to read primarily into this when we see in one of the provisions in the statute a term like principally engaged. It's so clear the General Assembly could have used similar language when talking about, you know, what qualifies as a manufacturer, or using the term manufacturer, manufacturing industry.
Your Honor, back to Midrex. Court cited another case that a legislature declined to enact a statute with specific language does not indicate the legislature intended the exact opposite, which was sort of anything goes. And in Midrex, the court recognized that if that taxpayer, which in that situation wanted to be called a contractor, could just say, we do some sort of contracting-like things occasionally, mainly for sort of the tax reason, we get to be a contractor. The court realized that that would be the wrong result, and it would not allow the statute to be implemented properly, and would basically negate it. We've relied on, I think, 4 cases principally: Henderson v. Gill, Duke Power, Clayton Marcus, and Midrex. And from those cases, we get these terms from this court. Under Henderson v. Gill, something done only incidentally to the main business. If you sort of let that tail wag the dog, then that doesn't work. The court said this exemption is lost. Something that is, in Duke Power, something that is only a subordinate enterprise, that's not sufficient to change the classification when we have to make a determination one or the other. In Midrex, something that's done only to a relatively small amount, that's not enough. And then finally in Midrex, primarily. So in those, and that's also stated in Oscar Miller, which is a Court of Appeals case, which kind of neatly summarizes this court's reasoning in Clayton Marcus. All of those cases, we think, get us to this point. It's necessary for a company that claims to be a manufacturer to resell, and primarily resell, what it sells. Give me just a minute. I've kind of covered a lot. Okay. And again, this would, what this decision would allow a company to do. I mean, this is not really a 50-50 case. It's more of an 82-18 case. But the business court's decision would allow a taxpayer like FSC to say, we sell just a little bit of what we produce for ourselves. Under the business court's decision, that qualifies because the business court was hesitant to come down to a particular percentage. That being FSC is practically saying we don't have to sell any. But the business court did rely to a certain extent on Clayton Marcus and said we see a resale requirement in the statute. We just don't know how much, so we're going to allow a little bit. But what I'm saying is that that little bit would allow a taxpayer to claim, a taxpayer that's sort of in you know, a large business operation like FSC, to say, we get to change hats. We get to change hats from contractor to manufacturer simply because we sell a little bit. FSC registered and collected sales tax, or actually didn't collect sales tax, as a contractor. It took all the advantages of being a contractor. But then for purposes of this exemption to buy equipment, it deemed itself a manufacturer. Why? Based on something it did to a relatively small amount. That again opens the door, that's wrong in itself, and it opens the door to somebody saying, you know, to FSC, saying, well, we sell a little bit. We sell a teacup. We sell a thimble full of asphalt. I know that's unlikely, but that's all they would have to do. Under FSC's reasoning, they would not have to sell any. Plain language is the statute. But as I said, Clayton Marcus tells us that the law has moved on. Under the business court's ruling, the business court did bolster its argument using the fact that, using Clayton Marcus, the fact that FSC sold some of what it produced. Under the business court's reasoning, there would be no limit. The taxpayer could simply say, we sell a little bit, we sell a smidgen, and therefore we come under the business court's ruling.
Are those our only two choices, that either it's primarily or it's any amount? Isn't there, I mean, why not a test that says they have to sell a substantial amount? And then we would look at, you know, whether 20% constitutes that. You seem to be presenting us with a sort of, you know.
I would ask the court not to repeat the reasoning of the business court, however. Substantial amount, what we have relied on, what the Department of Revenue has relied on, has been things like midrex, which is a fairly recent case for the department, where the court did agree primarily, where you have to sort of say, what is this? And you've got two choices, binary. And you say, well, it's, and as the court said in midrex, we have to treat the whole taxpayer as if it were all doing the primary thing. That's for the tax reporting requirement. In this case, they're going to be paying, the similarity to this case is that at the time that it purchases the equipment, FSC is going to have to sort of declare itself as either a contractor or a manufacturer because everything is done at the point of sale. Most days of the week, it's a contractor. In its brief, FSC says we primarily do 5 things. That's strange. You know, most people do primarily sort of 1 or 2 things. You can't do primarily 5 things. But the last one on the list is to sell some of the asphalt that they ordinarily make for themselves. Coming back to midrex, midrex says, what are you for tax purposes for this time? Ordinarily, FSC is a contractor. It's sort of, you know, it has all the earmarks of a contractor. As a contractor, it is sort of going down one path in terms of the sales tax. As I said, it's not going to be selling goods that will then later recover sales tax payments for the state. At the same time, it is saying, but as to our purchases, we're a manufacturer, our purchases of equipment. But that is inconsistent with the notion of a contractor. Both FSC and the department have to make that determination, either or. Midrex guides us on how to do that. That's also in some ways the case of that happened, it's also the situation that happened in the Duke Power case. The Duke Power case is the one that primarily gives us the principle that, or just the statement that it's an undefined term. That in that case it was manufacturer, I think. That's an undefined term. And so you have to go to the dictionary and so forth. And the principle holding there was that making the fly ash from coal was making something new, so it was manufacturing. The ultimate holding of the case was that since it was the fly ash equipment was an accessory to the production of electricity, it was exempt under the statute because the word accessory was in the statute. This court, in the decision, comes close to saying, well, you know, they sell the fly ash. It's used by the construction companies to make concrete. And so can't we hang our hat on that? They make a few tens of thousands of dollars a year selling the fly ash. That's sort of in the position of, that's temporary, you know, for a moment, that looks like this case. But the court said, well, wait a minute, that's really not the reason. That again lets the tail wag the dog. That's a minor thing that they do. What they mostly do, this is Duke Power. They sell electricity. That's what they use the coal to make. And they definitely sell it. So we really need some connection to the big activity to be able to characterize the whole activity for purposes of buying turbines, smokestacks, and the fly ash equipment. As to the fly ash equipment, the door to exempting it was that it was an accessory to the sale of electricity, which was Duke's primary business. Duke Power is primarily a utility, not a fly ash maker. So again, and my time is out. Thank you. Okay.
Thank you, counsel. We'll hear from the appellee.
Shorter than and not nearly as good looking as my friend. Mr. Chief Justice, Justices, may it please the court. I'm Lee Hogwood, and along with Mr. Womble and Mr. Sutton, we represent FSC2, a manufacturer. FSC2 is a manufacturer because it uses knowledge and skill to turn raw materials into hot mix asphalt. It purchased equipment which it incorporated into a manufacturing plant that, when operated with skill and specialized knowledge, turns raw materials into an entirely new thing. That is manufacturing. The unambiguous North Carolina statute at issue here created a preferential tax outcome for FSC2, and it purchased the very equipment which it relies on to manufacture a hot mix asphalt. That preferential treatment is commonly referred to as the mill machinery exemption. The Department of Revenue proposes to amend the statute. They wish to add words and concepts that cannot be found in it. They assert that manufacturing HMA requires more than manufacturing.
And Counselor,
Yes.
I would like to explore this with your friend on the other side, and perhaps in his rebuttal he'll be able to do so. But you mentioned that the Secretary of Revenue would like to amend the statute. Can you address for me your position on any of the administrative bulletins and proclamations that have come from the Secretary and what weight we should give them?
Well, there are two that are important here. There's a bulletin and an administrative rule, and each of them focus specifically upon contractors. And as Judge Davis concluded below, they do not address the situation where you have, as is the case here with FSC2, a hybrid operator. We also would say that this is a matter of statutory interpretation of an unambiguous statute that the courts have the duty to interpret and evaluate, and that the Secretary's views, while important, are not persuasive, controlling, or have any sort of effect in terms of this court's ability to read this statute, conclude that it is as unambiguous as the courts below concluded it was, and that the Secretary's view is simply wrong.
And as a follow-up, the statute that they argue vigorously, there are two parts, and I'm just paraphrasing because I don't have it right in front of me. The first part says that, at least by statute, we should give some deference, or I don't know if the right word is deference, but that the Secretary can make these interpretations. But then also the second part talks about how it's important that the taxpayer be protected. There's actually language there. Thank you. There's language there about protection of the a taxpayer. Could you address that for me, please?
I think I know the portion that you're referring to, Your Honor, and the notion is that when there is an ambiguity, and we contend there's not one, that the tie goes to the taxpayer, that this is an issue of notice. And what the statute says is if you are a manufacturer, which our client most certainly is as it relates to HMA, there's no assertion, no language in the statute to suggest that there's some primary purpose doctrine, and indeed, as Justice Allen pointed out, there are numerous other statutes that do include a primary purpose concept. There's no notice to a taxpayer that this equipment that they may purchase to utilize in their plant is somehow subject to the higher sales tax, and indeed, instead, it should be subject to the lower mill machinery exemption.
And what I'm grappling with is, do we have a separation of powers issue here?
Well, I think, Your Honor, that was where I was headed with the next.
Then proceed, sir.
The next point, and I think, yes, the answer to your question is yes, absolutely. The executive branch is attempting, in our view, to amend the statute by adding a primary purpose doctrine. They have now invited the courts to join them in this legislative exercise. And
why isn't Clayton Marcus controlling?
well, Clayton Marcus, first of all, Your Honor, dealt with the raw materials exemption, and it addressed a question of double taxation with respect to raw materials. And so the conclusion of the court in that case to sort of impose a primary purpose, or at least the purpose with respect to the swatch books, that they had to be sold to a third party, was an issue of, well, we didn't collect the tax on the raw materials, and this is not going to be sold, so there's no tax collected. That's not the case here with respect to preferential treatment with respect to the purchase of equipment to be utilized in an operating plant. Either the HMA is sold to a third party, in which case sales tax is paid by that third party, or alternatively, it is used in FSC2's operations, in which case use tax is paid in connection with the delivery and laydown of the asphalt where FSC2 is operating as a contractor to put down asphalt. So, one, Clayton Marcus was probably wrongly decided. It imposed this sort of preferential, or I'm sorry, imposed a primary purpose doctrine into a statute that didn't contain that language. But it doesn't control this situation because it dealt with a completely different statute. That is the exemption related to raw materials, not related to the purchase of equipment, mill machinery to be utilized in a manufacturing plant.
So are our choices primarily sort of following Clayton Marcus, or the manufacturer of any amount qualifies a company as a manufacturer? Is there any other choice here?
I think based on the facts of our case, the choice is not so stark. Our client, as Judge Davis stated, manufactures a huge amount of hot mix asphalt during the period in question and continues to do so. It sold to third parties not an incidental amount, it sold a substantial amount of hot mix asphalt. But the statute, when you look at the statute, Your Honor, it contains no requirement with respect to the primary purpose. And you have to, I think, consider for a moment, how does this come up? Our client buys a piece of equipment that it then installs into a manufacturing plant. That happens at a moment in time. That equipment is utilized over 7, 10, 12 years, however long its serviceable life is. The taxation decision occurs at the moment that that equipment is purchased, and it goes into a plant, and that plant has multiple uses. It has one use. It produces hot mix asphalt, but the destination of that asphalt is to be sold to third parties. It is to be used in the contracting business of our client, but all of that asphalt gets laid down on the roads and parking lots and businesses of the state of North Carolina, and one form of tax, a sales tax when it's sold, or a use tax is paid when it's utilized by our client. So there's not this notion of it's getting preferential, the equipment is getting preferential treatment as it's being purchased to, among other things, encourage manufacturing businesses in the state of North Carolina, to allow developers to acquire asphalt at a better price so that development and the things that we want to encourage in our state occur. It's not a situation like Clayton Marcus where it was either or. It's either going to be taxed as a raw material going in, or it's going to be taxed as a sales tax when sold. This is not that situation.
So just, thinking about it as a matter of statutory interpretation, here's where I'm struggling a little bit. The Secretary wants us to read the word primarily into the law. If we aren't inclined to do that because the General Assembly could have put the word in there, but it didn't, given that, the point or the goal of statutory interpretation is to effect the intent of the legislature, we're left with, well, do we really think the legislature meant that the production of any amount of something will turn, a company into a manufacturer? And if we're not willing to go that far, if we adopt a substantial requirement, well, then aren't we also putting a word into the statute that's not there?
So I argued at the business court level, and I'll argue again, that the statute says manufacturing, and it doesn't impose any sort of requirement that any portion of the produced material be sold, substantial, incidental, incremental. It says that a manufacturing plant that purchases equipment for use in that manufacturing plant is entitled to the exemption provided for mill machinery.
Let me give you a possible explanation for that and see what you think that may get to Justice Allen's concern here. Is that in many areas of the law, I'm not troubled by the idea that the court is going to, through case law, create meanings to things like words like manufacturer. So in tort law, for example, that we just understand that's how the common law works, but the tax code is about as far away as you can get from kind of the traditional common law. It's this dense, codified thing. And so the idea could be there is no intent to what the legislature is doing in the tax code except what's right in there. in the words, because what every legislator understands is that people comb through that thing and look for the loopholes. That's just how it works. And so if they find one and the Revenue Department says, wow, they're doing 1% manufacturing and 99% contracting, but they're getting the exemption here, they alert the legislature and they close the loophole. They define manufacturer. And that way the policy decision is being made by the legislative branch. And if that's in any other scenario, when the government is coming to this court, we just say, look, we don't consider whether this was intended or not, that this loophole is here. It's in the plain language of the statute, and so it's there until the legislature fixes it. What's your reaction to that?
I think I agree with you entirely on that point. And indeed, the legislature may choose to fix what is perceived to be a problem. It may, in fact, conclude that it's not a problem. And to just give a really current example, we have coming into this state several very significant contract manufacturers who are going to employ thousands and thousands of people and generate a number of really high-paying jobs. None of them sell, neither of them sell anything to anyone. They get paid a fee by their principal for producing the thing, whether it's an iPhone or some other manufactured good that is then sold to the consuming public, but the manufacturer sells nothing. We are encouraging that sort of business to develop in the state of North Carolina. If the legislature wants to do something about that, change the result as to what happens to the equipment that those entities purchase, they can hold hearings, they can receive input from the numerous various interested parties, the business community, the consuming public, everyone else can communicate about that topic, but that's their job. And indeed, a decision by this court that affirms the courts below compels that discussion. And the discussion may be, wow, we didn't know we went that far with this manufacturer's exemption, we're gonna fix it. Or, that's exactly right, that's what we intended. But we're not gonna know if we sort of fix it on the margins substantially, primarily, some other phrasing that the judiciary may impose based on what the executive wants. And indeed, I mean, the executive branch can lobby the legislature to fix the statute in the way that they have sought to fix it by imposing burdens on our client that are not in the statute.
Counsel, assuming we affirm the business court's ultimate holding without getting into, well, does 1 ounce count or does it need to be a substantial amount? I understand you also have issues with the idea of DOR. You took issue with their rulemaking process, and it was significantly, at least based on notice. Would there still be a problem if we affirmed the business court, if DOR came back and made some sort of substantial amount rule through the proper APA process? Would there still be a problem in your mind then with inconsistency with the statute?
I think there would be a problem with that, with inconsistency of the statute, but at least if they followed the rulemaking process, then there would be opportunity for interested parties to participate to a degree in that rulemaking process and presumably engage the legislature if that rulemaking went too far. But Justice Riggs, that's not what they did here. They made something up based on fairly their analysis of various cases that have nothing to do with the mill machinery exemption. All of those cases deal with other tax statutes that are not this one.
But reasoning from prior cases involving slightly different facts and slightly different statutes is what, that's sort of the enterprise of doing the law. And so I do want to get back to how this court has previously said statutes similar to this should be interpreted, and ask you if you aren't also asking us to consider that Midrex was wrongly decided, and actually on 2 points. So first, on the question of whether or not you need to have the word primarily in the statute in order for the department to understand the General Assembly to have meant that there needs to be some requirement of something more than a minimal or nominal or de minimis involvement. But then also on this question of how statutes are supposed to be interpreted, because earlier you had this discussion about, because it's taxation, it should be interpreted, construed in favor of the taxpayer. And that argument was raised in Midrex. And this court said that the court has held that tax statutes providing for exemptions to otherwise applicable general rules should be construed against the taxpayer. So aren't you asking us to essentially overrule Midrex on 2 points?
Let me address if I may, let me address the first point. So Midrex was focused on what was an income tax allocation question for a multi-state enterprise. And to qualify for a certain form of allocation, Midrex either was or was not a contractor. And there was beneficial treatment for Midrex under the statute if it were a contractor. Midrex designed buildings and they sold that design, but there was no suggestion that Midrex was a contractor in the sense of constructing buildings. So I think the court used the term primary, but Midrex was not what it was asserting that it was under the statute. In our case, we manufacture hot mix asphalt. There's no dispute about that. That was agreed to in the stipulations, and no one can say that we do not manufacture a lot of hot mix asphalt. It is true that the case, and there are a number of cases that suggest that exemptions are construed narrowly against the taxpayer. I think the right construct is they're construed narrowly. And even construed narrowly, when you read this statute, it says that there's an exemption available to a manufacturing plant. We own and operate manufacturing plants. That's what we do. And so I think I'll take a narrow construction and say the court does not have to overrule Midrex to affirm the business court or rule in our favor in this instance. I think it's a very different statute that required an either-or determination, and that's not our case. Did I answer your question?
Yes, although it seems to me that, so then you're basically saying that the definition of manufacturer doesn't require any percentage of sales at all.
The statute does not suggest that the definition of manufacturer requires any sales to a third party. And I gave the example of these contract manufacturers that are coming into our state producing thousands of jobs. They don't sell a thing to anyone. They manufacture something and they get paid a fee for doing it because they have a primary and single source to whom they are delivering these manufactured goods.
So then what is your response to the initial argument we heard that this eviscerates sales tax generally, because anyone who basically makes anything, they don't even have to sell it. If they just make something, they don't have to pay a sale.
I don't think that's a fair critique of the argument that we're making. We have a substantial manufacturing business. I think the Department of Revenue is capable of discerning the difference between I don't want to use the word fraud, false claims of being a manufacturer versus the conduct of a large business that operates across the state of North Carolina and produces hundreds of thousands of tons of I mean, that struck me as sort of the henny penny sky is falling in kind of argument that's something that they're capable of solving on individual basis if a taxpayer is not really functioning as a manufacturing entity.
Could they also solve that through rulemaking?
I think they could if they do it properly and address what constitutes manufacturing from a proper rulemaking function, subject to, of course, legislative oversight.
But I understood your answer to my question to be that because in the statute there isn't a numerical threshold, whether it's I sell 2 loaves of bread, I sell the substantial amount that FSC does, or it's a majority, that there still would be some rulemaking problems or critiques or attacks on DOR's rulemaking on that front.
If I may have misunderstood. I think that the department has obviously the authority to make rules following the proper procedure, and then the question becomes whether those exceed their statutory authority or are inconsistent with the statute. And it seems to me, based on the other questioning, that certainly at the base level of deciding whether there's a proper claim of an exemption, the department enjoys a certain level of authority to evaluate the truthfulness of a taxpayer's claim. Well, let me conclude, just unless there are further questions, I'll just conclude by asking the court to reject the DOR's invitation to legislate, and that we leave that to the folks on Jones Street, and that you affirm the decision of the courts below. Thank you very much.
Thank you, counsel. Rebuttal.
Your Honors, we're always in circular reasoning in this case. Because they manufacture a lot in the sense of make, then they are manufacturers. But in Clayton Marcus, this court agreed with the Department of Revenue that Clayton Marcus was not a manufacturer as to the swatch books, even though it made them. So the laws moved on from the simple statutory text, and we're asking the court to do what it did in Midrex, and what we think it's done in several cases, going back to Henderson v. Gill, which is an old case. In Midrex, the court very carefully said we can't read words into the statute, and then proceeded to do something that led to a ruling that it had to be, Midrex was not primarily a contractor. Going back to Clayton Marcus, court agreed that Clayton Marcus was ordinarily a manufacturer, made furniture, no question. It made the swatch books, but for purposes of the statute, it was not a manufacturer with respect to the swatch books. Transposing that into this case, you have the asphalt made for own use, the asphalt made for resale. As to that, as to the asphalt made for own use, similar to the swatch books, just different proportion. Under Clayton Marcus, FSC is not a manufacturer. So that's, instead of all the furniture swatch books, it's 80% of the asphalt, not a manufacturer. 20% is because it's selling it.
So I apologize.
I'm sorry, yeah, sure.
No, go ahead.
But they're claiming 100% of the sales tax exemption for 100% of the equipment that they use to make the asphalt, all of the asphalt.
Is the department exempt from rulemaking?
It is not, Your Honor, but the department also has various other tools that it can use, bulletins and so forth. The department, I'd like to say, is also in the business of day-to-day interpretation of statutes. That happens at every level.
Right, and
Yeah.
on that, isn't the interpretation of statute, doesn't that go to what a rule is? The interpretation and implementation?
It does, Your Honor. But in light of this court's, we think, clear reasoning in other cases, I mean, when this court speaks, sometimes it doesn't speak again on the same issue for quite a while. But the department does rely on those cases, particularly Clayton Marcus. But even going back to Henderson v. Gill, what does the company major in, which is a really nice turn of phrase? What does it primarily do? Do power? What does it not do to a relatively small amount? And as to that's mid-regs. As to the relatively small amount, it's always pointed out that the amount of asphalt that was sold by FSC was enormous, okay? But that's only a proportion. It was still only...
By far, the largest manufacturer of that product in the state is not actually a manufacturer. So you see how it does seem to matter how much overall is being produced, wouldn't you agree?
That's a hypothetical. And I'm not criticizing it for being a hypothetical.
Right, well, I'm using it as a hypothetical to show you that there's a flaw in your argument.
That's interesting, Your Honor. But the thing is, which way does that go in making a rule? Because that might, in this particular case, what the department has before it is something that I assume is relatively sort of asphalt. It's all asphalt. It's the same stuff. It's sort of fungible conceptually. And they only sell about 18% of what they make. I don't know the asphalt market or whatever. But I don't know why that would, I'm not really sure why that would have to change the analysis. But the thing is, just focusing on this taxpayer, they only really sell a relatively small amount of what they make. It's interesting to me that from what I'm hearing about rulemaking, and this, I think the court is sort of concerned with rulemaking, it kind of sounds like we're damned if we do and damned if we don't. We will make a rule and then that will be not, will not accomplish everything. Or let's leave it for the courts to make a rule. It's almost as if, okay, if this decision below is incorrect, leave that to somebody else. Well,
That's the question, right? Should courts be involved in the business of regulation, or should it be the regulatory agency? And the legislature passes a statute and basically sets the parameters within which a regulatory agency can operate. And you can attempt to define terms and the public has input. Why is that the wrong approach here?
Your Honor, as the attorney for the Department of Revenue, I'm going to say that the agency should regulate, okay, kind of obviously for my client. But this is what we consider to be settled law, that you are not a manufacturer, and it sort of goes back to sales tax concepts that are not really expressed in these cases, but you are a if you're a contractor, another way to put that is you use it for your own fulfillment of contracts. That's distinguished from a manufacturer. The department just understands that. Most likely, contractors themselves understand that. FSC also originally registered and dealt with the department as a contractor. I'm not sure if I've answered the question, but yeah.
Counsel, you're running out of time, but I did have one question before we wrap up. That is, are there, this statute has been repealed, but are there other similar statutes you're aware of in the Revenue Code that raise this similar question or problem?
I don't know, Your Honor. Your Honors, it's, again, kind of led off with the problems that this decision below would create. I just wanted to point out that it's interesting that the decision below and FSC itself, the business court and FSC are not on the same page. They leave things kind of hanging. We're appealing from the business court's decision, which would allow, like I said, just a teacup's worth of something sold to
Counsel, I
determine
believe your
the full
time's
characterization.
expired. Your time's expired.
I'm sorry, Your Honor.
Thank you for
thank
being,
you.
thank you
Thank you
for
very
being
much.
with us.